Hi, everyone. Joining us now is Ms. Megan Ingram, an attorney with Steinbecker Goodall York Chalk, specializing in outer care and special needs law. Megan leads the firm's special needs planning department and focuses on wealth protection, business succession, and estate tax planning. We are pleased to have Ms. Ingram here for the session Legal Planning Tools for Holding and Transferring Wealth, which includes a Q&A session after her presentation to address all your questions. Please welcome her.
Hi there. Good afternoon, everyone. Can everyone hear me okay? Fantastic. Thank you. Well, thank you so much for the opportunity to be here with you today. Whenever I received the invitation, I didn't have to think twice about it. I'm so honored to be here with you and for letting me spend this time with you today. So as Lena mentioned, my name is Megan, and I'm going to be spending the next hour talking through some different legal planning options whenever you have a loved one who has a disability or some kind of underlying health condition, and figuring out the best way that we can preserve wealth, transfer wealth with that individual in mind. So I always have to start off with just a couple of disclaimers. You know us lawyers, we always need to be giving our disclaimers. So I am licensed to practice law in Pennsylvania. So I understand that there could be quite a few attendees today who do not reside in the state of Pennsylvania. A lot of what I'm going to be talking about today can vary and can carry over into other states. But a lot of what I'm going to be talking about today is state-specific programs. So there could be details that vary from state to state. So if you see anything today that piques your interest and you want to check out in your home state, I'm hoping that there's a lot that can transfer, but I just have to encourage you to speak with someone who is licensed to practice law in your home state to see exactly what's going to apply for you back home. The second disclaimer I have to give is I am just one part of the team of people you should be talking with when you're doing this type of planning. So as an attorney, whenever I am doing this kind of planning with my clients, I am often working hand in hand with their financial advisor. Their financial advisor, of course, is the person who is working on how can we build wealth, create wealth. My job as the attorney is to figure out how is that wealth going to be titled? How is it going to be held? How do we make sure this wealth is going to be structured in a way that is going to make sure that this individual has the supports that they are going to be needing in the future? And of course, the last person in this group is an accountant, of course. We always got to keep our eye on taxes, right? So again, I am so happy to be here today sharing my piece of the puzzle with you, but you really got to be working with a whole team of people to get the whole picture of how this plan should be coming together. So as Lena said, I practice in Steinbacher, Goodall, and Yurchek. We are an elder law special needs estate planning firm with 7 offices across the state of Pennsylvania. I personally work out of our firm's State College office right in the heart of the state, right down the road from Penn State, if anyone's familiar with the area. And I focus most of my practice on special needs planning, which is an area that is near and dear to my heart because of this little guy up here. This is my son. His name is Jonathan. He just turned 4 years old 2 weeks ago today, and he is really coming into himself, as every 4-year-old does, right? But I absolutely love to work with other families who have a loved one who has a health medical history that we are factoring into a plan, trying to look through a plan to see how do we make sure our loved one is going to have the supports that they are going to need to help them be as fulfilled and as comfortable as they can be in the future. I know what that's like to go through that planning for my own son, and I absolutely love to work through those kinds of plans with other families as well. But with all of that said, one of the things that is such a crucial part of this planning, as all of us in this room know, it is so important that whenever someone has a disability of any kind or some kind of underlying health condition, the big question is, how do we make sure that this person is going to get the supports and the services that they need to make their life as comfortable as possible? And we all know those supports look and take on a variety of different ways. They look a lot of different ways. We have a lot of supports through families, through friends, in our communities. Whenever I'm doing planning with families, The main types of supports that I'm keeping my eye on, though, are the ones that have federal and state funding. There are a whole lot of different types of programs like this out there, of course. These are just kind of the main ones that I am most often working with families to obtain and to ensure continued access to. So, of course, the big ones are any kind of Medicaid, medical assistance. As I mentioned, I am only licensed to practice law in Pennsylvania. There are a whole lot of different types of these programs throughout the state. And since each state operates their programs a little bit differently, the programs for you in your home state might be titled something different, might have slightly different aspects to them. So if you hear me talk about anything that kind of sounds familiar from what you've experienced at home or what you've heard about at home, but it sounds different, might be the same program, but just looks a little bit different for you at home. So, of course, some of the programs that we're working with families to maintain and continue eligibility for are Medicaid, health insurance, and within that program, there's also a sub-program of MAWD, medical assistance for workers with disabilities, for an individual who is working, but their medical history indicates that they are so eligible to keep assistance for health insurance through the MAWD program. Or Ticket to Work is another program that we have here in Pennsylvania for a worker who has a qualifying medical history to continue to have access to health insurance. There are Medicaid waiver programs that provide home-based supports and community-based supports in the healthcare realm as well. And of course, some of the other big ones that provide some kinds of cash assistance to individuals could be Supplemental Security Income, otherwise called SSI. Not to be confused with Social Security Disability Insurance, SSDI. Acronyms are very similar, but they work very, very differently. I work with some individuals who are receiving services through the child disability benefits under SSDI, or they're receiving access to Medicare under SSDI. And of course, throughout the country, there are a variety of housing resources, nutrition assistance resources as well. And whenever we're taking a look at all of these different programs, as a planner, one of the things that I am keeping my eye on is who qualifies for these programs and what criteria does someone have to meet to be eligible for these programs. All of these programs have different eligibility criteria. Of course, there are some programs where the recipient has to have a qualifying medical history and they have to meet a certain asset limit or income limit as well. Of course, those types of programs include Medicaid health insurance, those Medicaid waivers for home and community supports. Supplemental Security Income also has a really strict asset limit that someone has to meet to qualify for SSI. Some other programs do not look at medical history. They only look at an asset limit or income limit, like some of those housing resources or nutrition resources for individuals. And finally, some programs like SSDI require someone to have a qualifying medical history and also a work history, either the individual's own work history or a parent's work history once the parent later retires or if that parent later has a disability or passes away. But as you can see, of course, my understanding through my son and through working with the other families that I work with, whenever someone has a particular medical history, some of these key programs that we're trying to maintain access for have to do with healthcare and health supports, right? And as we can see, the medical assistance, health insurance, the Medicaid waivers, those are under what I classified as Category 1. That means we have to keep our eye not only on the individual's medical history, but we have this asset component or this income limit that we also have to watch as well. Here in Pennsylvania, for an adult to qualify for medical assistance health insurance, they can't have more than $2,000. That's the asset limit. That is very, very low, right? Same thing for Medicaid waivers. To get those home-based supports or community-based supports, oftentimes the asset limit that we're working with here in Pennsylvania is $8,000. If an individual has more than $8,000, they might no longer qualify for their Medicaid waiver home-based supports or community-based supports that they're relying on. So of course the big question that we run into is, how do I build savings and still qualify for these services and supports? that I want to continue receiving. This could be, I work with individuals who say, what do I do with my paycheck? You know, I want to have more than $2,000 in my bank account. I want to have more than $8,000 in my bank account. How do I do that and still get access to the health care that I need? Or if I'm working with parents and they say, I want to leave an inheritance to my loved one, but I need to make sure that they still have access to their Medicaid services, to have these home health aides come in and provide the services, provide the sorts I know my loved one needs. And $8,000, we all know, that's not enough to provide those services, especially long into the future. How do we make sure that we still get access to these services, but we build some savings? And some options that I'm going to be covering today are some things that you might consider for yourself or for your loved ones here. Here are some of the tools that we have in our tool belt. The first tool is just what I'm going to be spending most of my time talking about today. Those are ABLE accounts. If an ABLE account is not something that we might be looking at, some other options that I regularly use are different kinds of trust that I'm going to be touching on a little bit today. But again, I'm going to be spending most of my time on ABLE accounts. ABLE accounts came into existence back in 2014. And I'm seeing that there are still some, there's not a whole bunch of popularity or knowledge about ABLE accounts. And I love ABLE accounts. I think they're a fantastic resource. So I'm glad that I get to take some time today with all of you to talk a little bit more about this type of account. So an ABLE account is an online account that is owned by an individual who has a disability. And it's a way that this person can build savings, save resources, while still qualifying for their federal and state funded services and supports. And I put in there, of course, you know, again, lawyers, disclaimers. I had to put in here that it's still able to qualify for most of their services and supports because once again, every state's ABLE program, every state's services and supports are going to be different across every state. And so this is where it's another really key area to make sure that you're checking with your state's ABLE program to see how is this going to affect the programs in my home state. But if you have an ABLE account, there are different kinds of ABLE accounts a person could have. It could work as a savings account. I've seen some options that work kind of like a checking account. I think some options come with a debit card for use. Or you can have an ABLE account that's structured as an investment account. Some states in their ABLE programs have partnered with outside investors like Capital Group, BlackRock, Fidelity to tap into some of their investment portfolios for people who are investing their money in an ABLE account if they choose the investment structure. The other thing I always like to note too is a person can only have one ABLE account. They can't have multiple ABLE accounts. You can only have your one if you're going to have an ABLE account. So, like the other services and supports that I mentioned, with an ABLE account, there are qualifications that someone has to meet in order to be able to have an ABLE account. So right now, the law that exists today is that an individual to have an ABLE account has to have a disability that began before age 26. A new law has been passed, and starting on January 1st, that age is being bumped up to 46. So as long as a person has had a disability that began before age 46 as of next year, they're going to be able to have an ABLE account. And one key distinction I always like to note out is we need proof that the disability began before age 26. We do not need to have a diagnosis before age 26. Two very different things for ABLE criteria. So then the next big question, of course, is, well, how do they define disability? If you are someone or if one of your loved ones has gone through the application process for some of these different programs and supports like Medicaid, like Social Security, you've probably seen that all of these different groups define disability very differently, and they're looking at medical history a little bit differently. Well, in ABLE, there are a couple of different laser pointer's not working. Sorry, guys. You're just going to have to follow along with me. But there are a couple different ways that someone could meet their definition of having a disability. First off, if someone is already receiving SSI or SSDI, ABLE says, okay, if you already passed Social Security's definitions of having a disability and you qualify for SSI or SSDI, that's good enough for us too. You automatically qualify for an ABLE account. Option 2, even if someone is not receiving SSI or is not receiving SSDI, a person could still qualify for an ABLE account if they meet that definition under the second arrow there. If someone has a marked or severe functional limitation that has lasted for the last 12 months, or is expected to last for the next 12 months, or is expected to result in death, or if somebody is blind, those are kind of the three doorways through which someone could enter into access to an ABLE account. If you are trying to qualify for an ABLE account under that second option by confirmation of a marked and severe functional limitation, then you have to submit a disability certification that is signed by your doctor, that confirming that you have this diagnosis. And I also included just a list there on who qualifies as a doctor under ABLE standpoint. So it has to be someone that has one of these credentials. You'll note here that a PA is not someone who is listed as who can sign off on this disability certification. A nurse practitioner is not someone who could sign off on this disability certification. You have to have someone with one of these credentials signing off. So let's say, we're going under this definition. How do the case managers at ABLE determine if someone has a marked and severe functional limitation? This is where the gray area begins, right? And oftentimes, whenever I'm sitting down with my clients and we're looking at this application process, this is where I say, unfortunately, this is where it's really going to come down to the case manager, to the ABLE employee who is taking a look at the application, taking a look at the individual's medical history to determine if this definition is met. So some of the guidelines that they have for ABLE, and I put in there the citation to the Federal Register that lists these definitions if anyone is like me and you get really excited to look at codes and laws. There's your site. You can go look it up too. But it can be either a physical impairment or a mental impairment. They do have a list of what they call compassionate allowances. If somebody has a diagnosis that is included on this list of compassionate allowances, that's an automatic qualification for an ABLE account. The last time I checked, I do not believe RYR1 is on that list of compassionate allowances. But even if someone does not have a diagnosis on that list of compassionate allowances, if it can be proved that that person has a marked limitation in two areas of functioning or a severe limitation in one area of functioning, they might still qualify for an ABLE account. And I included up here some of those areas, some of the domains of functioning that are considered. So there are areas related to acquiring and using information, attending to and completing tasks, interacting and relating with others, moving about and manipulating objects is something else that they consider. Caring for yourself and health and physical safety and well-being is another section that they consider as well. Overall, they're looking to see, does someone have a medical condition that seriously interferes with their ability to independently initiate, sustain, or complete activities? That's part of the definition that they're looking at to see if someone qualifies for an ABLE account. And once again, this is something that it might ultimately just come down to the individual reviewing an application to determine if this definition is met. But let's say you want to submit an application to see, and if you meet this definition, here's the question: why would I even want to go through the application process? What's so great about ABLE accounts? Why would I want one? Well, the first big benefit to an ABLE account is if somebody is receiving any kinds of services and supports that are funded through state or federal governments that have that asset limitation, like medical assistance, like those Medicaid waivers, the money that is saved in an ABLE account is not counted when the government is counting the individual's assets to determine if they qualify. So somebody theoretically could be eligible for medical assistance with that $2,000 asset limit, have money in the ABLE account, and Medicaid's not going to look at the money that they have saved in an ABLE account when determining if they qualify. But here's the other big benefit to ABLE accounts. The money in an ABLE account grows tax-free of federal income tax, and it's exempt from federal income tax when the money is withdrawn as well, as long as it's used for a qualified disability expense. So even someone who is not receiving any services and supports through programs that have that asset limit, even if bullet point 1 up there is not of interest to you or your loved one, this could be an account that could be used for tax-free growth. I have in there as well, again, to double check, as I said, the money in an ABLE account grows federal income tax-free. It might also be growing state income tax-free. You have to double check your state's program. I know here in Pennsylvania, the state of Pennsylvania also does not impose income tax on money in an ABLE account as well. But of course, that's something that is going to differ amongst states too. So let's say you go with an ABLE account. How can you use the money that you have in an ABLE account? Where money in an ABLE account is able to be withdrawn for what they deem to be qualified disability expenses. And they boil this down to say it's any expense that relates to an eligible individual's disability and something that benefits that individual. They give some examples here, but they make a note that says this is not the only list of things you can use. My understanding is that what you can use the funds in your ABLE account for is really broad. Some of the examples that they give include anything that is related to education, employment, food, housing, transportation, any kind of assistive technologies, personal support services, legal fees, of course, often thrown in there as an available expense, any funeral and burial, health prevention, wellness, financial management, any kind of expenses, of course, for ABLE account monitoring. Similar to 529 educational plans, ABLE accounts also have pretty minimal management fees as well, or anything related to self-employment related expenses. The list is really broad of what you're able to use the funds in this ABLE account for. And once again, if you are withdrawing money from your ABLE account and you're spending it on something that is a qualified disability related expense, just as that money was growing tax-free in the account, it's not going to be taxed when you pull it out later if the expense is a qualified disability expense. If you pull money out of an ABLE account and for something that does not qualify as a qualified disability expense, tax is going to be incurred then on what you pulled out. And it's possible as well that the state might impose a penalty too. I know here in Pennsylvania, the penalty that they impose whenever money is withdrawn for something that's not a qualified disability expense, it's a percentage of what was withdrawn from the account. So if someone is withdrawing a pretty minor amount, the penalty period could potentially be pretty small. That's something that someone might deem it's still worth it for me to pull this money out of the ABLE account because the penalty in the income tax is something that I'm willing to pay. It's not going to be that significant. I also just have a note down there in the bottom right-hand corner to watch out for the timing of withdrawals. If the ABLE account owner is receiving any types of services and supports funded through the state and local government, like if someone is receiving SSI, if someone is receiving medical assistance, sometimes, so how these withdrawals happen is money comes out of the individual's ABLE account, it's transferred into the individual's checking account or savings account, and then they spend it from there. Sometimes, whenever money comes out of the ABLE account, some rules are that it has to be spent within a certain amount of time after it comes out of the ABLE account. So if the account owner is participating in SSI or one of those other programs, it's just really important that they understand what those withdrawal rules are and how long they have to spend the money after it comes out of an ABLE account. So how do we put money into an ABLE account? Like I mentioned, ABLE account is an online account. It's not something that you can go into a physical branch, any kind of physical bank branch, and deposit money into. So it's putting money into an account. It requires an electronic transfer from someone's checking account, savings account, into the ABLE account through the ABLE account website. We can only put cash in an ABLE account. You cannot transfer other types of assets. That is one of the limitations of an ABLE account. We cannot transfer stock into an ABLE account. We cannot put real estate into an ABLE account. We can only be putting cash in an ABLE account. One thing that was recently updated, which I think is fantastic, is they now allow here in Pennsylvania, if someone has money in a PA 529 educational savings plan, there is an allowance where you can roll over money in a PA 529 educational savings plan into a PA ABLE account without penalty. So that could be another source of funding for a PA ABLE account. As I mentioned, one of the limits on ABLE account is what can we put into it? We can only put cash in it. But there are also restrictions and limits on how much we can be putting into an ABLE account. So there is a limit on how much somebody can deposit into an ABLE account every year. Right now, that number for 2025 is $19,000. The amount of new deposits into an ABLE account cannot exceed $19,000 in 2025. If that number rings a bell, if it sounds familiar, it's because $19,000 is also the federal estate tax, the federal gift tax exclusion limit, the amount of money you can give away to a person, not have to report it to the IRS. That limit of what you can deposit into an ABLE account, it tends to change every year. The pattern that we've been seeing for the past 5 or 6 years is it tends to go up by about $1,000 every year, so it is growing. There's also a maximum on how much can be in an ABLE account balance altogether. If the account owner is receiving SSI, they cannot have more than $100,000 in their ABLE account and still avoid the scrutiny of Social Security. If a recipient of SSI has an ABLE account and they have more than $100,000 in their ABLE account, then the excess over $100,000 begins to be counted toward their asset limit that they have to meet for SSI. But if somebody is not receiving SSI, if the account owner is not receiving SSI, then each state is going to determine what the maximum is that you can have in an ABLE account. Here in Pennsylvania, for a PA ABLE account, it's a little over $500,000. I believe the exact limit off the top of my head is that an individual cannot have more than $511,000 in their ABLE account. So again, this could be around $500,000. That is getting tax-free growth if it's in the form of an investment account for someone who qualifies for this type of an account. So let's say we have an ABLE account, it is funded, and then the account owner passes away. What do we do then? What happens to the money left over in an ABLE account? Well, one of the big things that we always have to watch with ABLE is if the account owner was receiving any supports through Medicaid, through medical assistance, through a waiver, any types of home-based care, long-term care supports, there is this thing we have to watch called the Medicaid payback. I'm not sure if that rings a bell, if that's something that anyone has heard about in here. But if somebody is receiving Medicaid or medical assistance, Medicaid is keeping track of all of the dollars it spends on someone's care during that person's lifetime. And then whenever that Medicaid recipient passes away, it's possible that Medicaid might try to pay themselves back the amount it's spent on that person's care during their lifetime from the money that that individual owned whenever they passed away. If the Medicaid payback applies to an ABLE account owner, it's possible that the money left over in an ABLE account could be something that Medicaid goes after to try to pay themselves back from the care that it spent on the individual during their lifetime. This is a state-by-state determination. Right now, so I will say whenever the federal government created ABLE accounts and passed it over to the states to say, hey, states, we want each state to have their own ABLE program and to allow these types of accounts to your constituents. And whenever you are creating your ABLE programs for your state, you get to choose whether you're going to go after the money in an ABLE account for your Medicaid payback within your state. Right now in the state of Pennsylvania, I will say I do not see the state of Pennsylvania going after the funds left in someone's ABLE account to pay it back. But I always tell my clients, the federal government lets the state of Pennsylvania go after the money in an ABLE account. Pennsylvania could always change its mind in the future. They could change their policy at any point in time and say, we're now going to start to go after money left over in someone's ABLE account for this payback. So that's something else that we always have to weigh when we're determining how much do we want to put in an ABLE account. We're getting that tax-free growth. We could have $500,000 potentially in this ABLE account as a tax-free investment account. But the money left over in this account when the owner passes away could possibly be going back to Medicaid if that Medicaid payback applies to that individual. Now, otherwise, whenever an ABLE account owner passes away, let's set aside the Medicaid payback for a minute. The account owner can set a beneficiary on their ABLE account as to designate who's going to receive the money left over in this account when the owner passes away. If a beneficiary is not named on the ABLE account, then the money left over in that account is just going to go into the individual's estate and go according to their last will and testament or according to their state's rules for someone who passes away without a will. So as I mentioned, I wanted to include some slides in here regarding the ABLE National Resource Center. I know this is an international conference. Not everyone here is from Pennsylvania. And so you're going to be looking at ABLE programs potentially throughout the country. So as I mentioned, ABLE was created by the federal government, and then they turned the ABLE programs over into each individual state for each state to design their own ABLE program, exactly how each state wanted these accounts to be run for their residents. You don't have to stick with your own state's ABLE account. It's possible for a Pennsylvania resident to open up an ABLE account under New Jersey's ABLE account program, to open one up under Massachusetts' ABLE account program. You don't have to be a resident of the state to open up that state's ABLE account. But, again, another disclaimer, a lot of states have certain exclusive benefits to the account owners who are residents of that state that might not apply to other account owners who reside in other states. For example, Pennsylvania says if you're a Pennsylvania resident and you have a PA ABLE account, whatever you deposit into your ABLE account for the year, you not only get the tax-free income, the income tax-free growth, but you also get a PA income tax deduction for the amount that you deposit into an ABLE account. That is only available for PA residents who have a PA ABLE account. Similarly, the state of Pennsylvania says if you are a recipient of medical assistance or Medicaid, the money that you have in an ABLE account, we're not going to look at it whenever we're counting your assets to determine if you qualify for our state's medical program. But if you are a resident, if you have an ABLE account in another state, they might count your money in your New Jersey ABLE account, for example, when they're determining if you qualify for Pennsylvania Medicaid. So when you're choosing which ABLE account you're going to be using, take a look to see what perks do I get in my home state and what's available to me in other states. What could I be giving up if I open up an ABLE account under another state's programs? If you're wondering, well, why would I even go to another state's ABLE account? One thing that I've heard other people considering is, as I mentioned, your ABLE account could be an investment account in different states, partner with different kinds of financial institutions. I have seen some folks consider, well, the ABLE account in this state partners with Fidelity for their investment portfolio. I want to be in that portfolio instead of the investment portfolios that Pennsylvania partners with. That could be one reason why you choose one state over another. So here are just some kind of resources that you could look at. Each state has its own ABLE website. Here in Pennsylvania, it's paable.gov. And here's also the website to that National Resource Center that I mentioned. One of the great things that I love about the National Resource Center website is the comparison tool that they have. Here's a screenshot that I took from it. On this website, under the comparison tool, you're able to pick and choose and compare side by side different states' ABLE programs. So whenever I was doing this, you'll see I chose Pennsylvania, Ohio, and New Jersey. And you can see that all of them offer enrollment to out-of-state residents. You'll see, for example, under Section 2 there, I mentioned that the Pennsylvania ABLE account offers their in-state residents a PA income tax deduction for new deposits into an ABLE account. Ohio does, but it's a cap. They don't let their residents match dollar for dollar that income tax deduction. New Jersey does not have an income tax deduction for their in-state residents. So that's an example of where you can kind of go down, and it goes on for quite a while. I only got a small fraction of the screen and all of the different comparison indicators that you can look at under the ABLE National Resource Center comparison tool if you want to look at different objects. So I mentioned there are those limits to ABLE accounts. You can't put more than $19,000 in an ABLE account every year. And that's also a flat addition. The amount of new deposits into an ABLE account cannot be more than $19,000. That is not, for example, I put $19,000 in my son's ABLE account, and then my mom puts $19,000 and my dad puts $19,000 in. Nope, it is a flat. The amount in the account cannot have more than $19,000 contributed to it in a year. So what happens if we are looking at a sum that's more than $19,000? What if, I'm working with someone who says, well, I earn more than $19,000 a year from my job. What do I do with that money and still be able to qualify for my medical assistance? Or what if I receive an inheritance from a loved one that is more than $19,000, or I want to give an inheritance to my loved one that's more than $19,000? What do we do with it then and make sure that they still qualify for their medical assistance and for their health supports? What happens if I already have $500,000 in my ABLE account? I can't make more contributions to it. Or another huge limit that I see with clients, whenever I'm working with parents, grandparents, or other loved ones who want to leave assets to an individual who's receiving these services and supports, they say, well, I'm not just leaving cash to them. I want to leave another type of an asset. I want to leave our home to my child. I want to leave real estate. I want to leave this investment account. Well, as I mentioned, we can't put real estate in an ABLE account. We can't put stocks in kind into an ABLE account. What are some other tools that we have in our tool belt for those types of wealth preservation and succession strategies? As I mentioned, that's where we look at a trust. There are a lot of different kinds of trusts out there that are used for a lot of different kinds of purposes. So you could have 5 different trusts that all look a little bit different, and they're all used for different purposes. But whenever I'm doing this kind of planning, some of the main 2 trusts that I am using whenever I'm working with an individual are either first-party special needs trust or third-party supplemental needs trust. You're going to see a lot of similarities. We're going to go through these in some more detail. You're going to see a lot of similarities between the 2 trusts, but really, really significant differences that limit when we're going to use one over another. And just before I start diving into the specific details, a trust at its core, a lot of times the first question I get is, well, what exactly is a trust? Which is fair. I didn't exactly know what a trust was before I started going to law school. So I think that's always a really fair question and a great place to start. A trust is a separate legal entity, separate from yourself, that's able to own assets and own property. As we're going to see, there's someone designated in the trust who's the trustee. That's the person who's allowed to manage the money that's owned by the trust and the assets owned by the trust and decide how it's going to be spent. And the trust has a beneficiary. The beneficiary is the person that whenever we're doing anything with the money owned by the trust, it has to be for the benefit of the beneficiary. That's the person who's able to use and benefit and enjoy the assets that the trust owns. So let's dive into some more details about these 2 particular types of trust. We're going to start by looking at a first-party special needs trust. This is a type of trust that is created by an individual who has a disability, maybe their guardian, a power of attorney agent, a family member, or anyone else. Here's the really key distinction for when we need to use a first-party special needs trust. The money that's going into the first-party special needs trust before it goes into the trust, it's able to be owned by the individual who has a disability. So let's say, again, my son is 4. But let's fast forward. As much as I want time to slow down, I don't want him to grow up too fast. Let's fast forward and say we're 20 years into the future. He's working. He's maxed out his ABLE account balance because he's earned more than $19,000 in a year. But he says, I still want to have access to my medical assistance health insurance. He can take his money, put it into a first-party special needs trust to still maintain access to his medical assistance health insurance. The money that's in a first-party special needs trust is also not counted as a resource when Social Security, when Medicaid is determining whether the beneficiary still qualifies for their services and supports. But other than the individual who has a disability, anyone else can also deposit money into a first-party special needs trust as well. The trust funds are invested and spent entirely for the benefit of the individual who created the trust. We have to take a look at, one of the big restrictions is going to be the trustee, the person who's managing the money in the trust. They cannot spend the money in the trust on anything that the beneficiary services and supports would otherwise provide. If it's something that their SSI or their medical assistance would otherwise cover, and the trust is paying for it instead, then we run the risk of Medicaid, of Social Security saying, well, if you have other resources, if you have a trust who's able to pay this for you, you don't need us. So the rules of a first-party special needs trust often say, take a look at what services and supports are available for this beneficiary through other resources, and try to utilize those first before you dip into the assets in a first-party special needs trust to try to minimize effects there. Here's another big restriction of a first-party special needs trust. The individual who set up the trust, who's the beneficiary, the individual who has a disability or underlying health condition of any kind, they cannot be their own trustee. They have to pick someone else to be the trustee. So they don't have the power to manage or invest the funds after it's transferred out of their name into the first-party trust. The trustee is the only one who decides how the money in the trust is going to be spent and when it's spent out. So the individual themselves is really giving up a lot of control in exchange for continued eligibility for their services and supports. This is very different from an ABLE account. An individual who opens up an ABLE account, they're the owner of the account. With an ABLE account, they still have access to the money in the ABLE account. They can withdraw it and spend it themselves, but they're giving up that freedom with a first-party special needs trust. But a first-party special needs trust does not have any funding maximums. We don't have a $19,000 asset limit with a first-party trust. We don't have a $500,000 account balance maximum with a first-party special needs trust. That might be why we're still looking at a first-party trust over an ABLE account. However, with a first-party trust, once the beneficiary turns 65, you cannot put any new funds, any new assets into a first-party special needs trust. I've run into situations, really unfortunately, where an individual is over 65. They have assets now that we need to do something with to maintain their eligibility for their services and supports, and a first-party trust is off the table because we can't do new fundings once the beneficiary turns 65. We can put assets other than cash in there, so if a beneficiary inherits real estate from a loved one, they might create a first-party trust and transfer their real estate into that trust to maintain their eligibility for services and supports. But here's the other thing, that Medicaid payback that I mentioned with an ABLE account, if the beneficiary is receiving Medicaid benefits, whenever the beneficiary passes away, if that Medicaid payback applies and Medicaid's going to try to reimburse themselves, the money in a first-party special needs trust is on the table for Medicaid to go after to use to reimburse themselves after the beneficiary passes away. This is another big thing that we have to think about and we have to be concerned about. We can name in the trust that if there's any money left over in this trust when the beneficiary passes away and after Medicaid takes their share out, if there's any money left over, we can say who it goes to next, but we're all very aware of the enormous healthcare costs, right? Whenever Medicaid takes their share out to pay themselves back for the healthcare costs, we usually say it might be kind of unlikely that there's going to be anything left over to go to anyone else after Medicaid does that payback. Well, that is one of the reasons why, if we have an opportunity, a third-party supplemental needs trust is a way to go. If I am ever working with parents, grandparents, anyone else who says, I want to leave an inheritance to my loved one who has a disability, my loved one is receiving SSI, they're receiving a Medicaid waiver, or I think they might in the future. I think they might need some health supports in the future, and I want to make sure that they maintain eligibility for whatever types of programs they want to pursue in the future. If we have the chance to plan ahead with someone who wants to leave their assets to a loved one, a third-party supplemental needs trust is the way to go, and that's the tool that I'm going to want to be using with my parents, the grandparents, the other loved ones in this individual's lifetime. So here are the big things. It is created by anyone other than the individual who has a disability. Someone who is receiving services and supports, they cannot create a third-party supplemental needs trust for themselves. It has to be someone else creating it for their benefit. Here's the other big restriction. It can only be funded with assets that belong to anyone other than the individual. So for example, I have set up a third-party supplemental needs trust for my son's benefit, and my last will and testament says whenever I die, I don't want it to go right to my son. Again, not only because he's 4, but I want to make sure that he's going to have access to medical assistance, to any other supports that he wants to pursue after he becomes an adult. So my last will and testament says, don't give my money, don't give my inheritance to my son directly, because then he's going to be way past that $2,000 asset limit. Put it into this third-party supplemental needs trust. Take my money, take my assets, and put it into this third-party trust that I set up for my son. Whenever my son becomes an adult and he starts working, if he has too much money to put into an ABLE account, he cannot use a third-party supplemental needs trust for his own money. But this is a trust that other people, myself, my parents, the other loved ones in my son's life can use to transfer their assets for my son's benefit. Similar to a first-party trust, the third-party supplemental needs trust language is going to say whatever resources and supports the beneficiary is able to have provided to them through other community outlets, whether it's through medical assistance, whether it's through other community supports, try to use those first. Don't exhaust the third-party supplemental needs trust assets on supports and services that could be funded through other options. And here's the other big thing. These options that we're talking about today, they are not mutually exclusive. It's very possible for an individual to have multiple types of these assets. Whenever I'm drafting a third-party supplemental needs trust, I always like to put into it that the money in a third-party supplemental needs trust can be distributed into the beneficiary's ABLE account. So where the beneficiary who has a disability, the beneficiary cannot be their own trustee and can't make their own decisions and control over the assets in the trust. The trustee can take up to $19,000 a year to put into that beneficiary's ABLE account for the beneficiary to have direct control and access and use over. So it's possible that we are using multiple tools hand in hand here. With a third-party supplemental needs trust, once again, there are no funding maximums. There are no limits on the types of assets you can put into a third-party supplemental needs trust. You can put real estate, you can put stock, you can put other types of assets, not just cash, into a third-party trust. And this can be funded after age 65. Unlike that first-party trust, which is off the table once the beneficiary turns 65, this can be funded after the beneficiary turns 65. There's no age limits that we have to abide by for this type of a trust. And here's the other benefit to a third-party trust: not subject to the Medicaid payback when the beneficiary passes away. Whenever I set up the third-party trust for my son, I wrote right into that trust, if there's any money left in here, whenever my son dies, I got to say who it goes to next. Does not go to Medicaid. Medicaid cannot touch this for the Medicaid payback if that's going to apply when my son passes away. So those are the 3 big tools. They are not the only tools. Again, these types of accounts and these types of tools are going to vary in every state, and it's very possible that there are additional tools available to you in your home state that I didn't cover today here in Pennsylvania. But here are the 3 main ones that we're looking at, and I created this chart. Maybe you could say I kind of stole this idea from the ABLE National Resource Center comparison chart tool, but I made up my own chart to compare ABLE accounts to third-party trust to first-party trust. So we can see, what types of assets can be held in each tool that we have, what are the limits that we're looking at with each type of tool, who can access the funds. So you can see in ABLE accounts, the individual themselves can have direct access to the funds in an ABLE account, but only the trustee can access the funds in a first-party or third-party trust. Does the Medicaid payback apply? And things like that. So you can see it's very possible that you're not just choosing one of these tools that we talked about today, you're choosing 2 or maybe all 3 of these to work into your plan. And once again, this is just my piece of the puzzle. I can take a look to say what works best for us, an ABLE account, a third-party trust, but it's so crucial that you're also working with a financial advisor to figure out how do we create and build the wealth to fund these tools and to make sure the supports are there for your loved one. Always very important that we're bringing the accountant in, because honestly, we could be here for another 3 hours just talking about taxes. And I know we're right after lunch. No one wants to hear me talk about taxes for 3 hours. But that's another really important tool to have in your planning team, to put this whole piece of the puzzle together for your loved one. So if you want to hear any more information, my firm, again, Steinbacher, Goodall, and Yurchek, we have a couple of other resources that you can look at. You can like us on Facebook. We have a YouTube channel. A lot of times the seminars that we do are recorded. I often do a webinar on special needs planning with a financial advisor who is a special needs consultant and has a special designation for this type of planning and working with families for financial advising and financial planning for an individual who has a disability. We recorded it. It is available on our YouTube channel. It is, again, Steinbacher, Goodall, and Yurchek. And there is a recorded webinar that gives you some more information on taxes and financial advising as well. We also have a podcast, and we now have an Instagram page. It's new to us. It's exciting to us. If you're on Instagram, give us a like and give us a follow. You don't like things on Instagram, do you? Sorry, guys. Marketing should have helped me more sell the Instagram page before they put it up here. Okay, so I still have about 9 minutes left. Does anyone have any questions? Yes. Sorry, I don't know if we have a microphone there. Okay.
Is there a look-back period on the ABLE account for Medicaid? So if you had someone and you were helping them manage it and they started to decline, could you just then plan to spend those funds down quickly?
Fantastic question. So as you mentioned, a lot of the services and supports that have an asset limit, depending on what you do with your excess resources, there could be a penalty period. The 5-year look back you mentioned, that's for Medicaid waivers and long-term care supports here in Pennsylvania. If you have assets over the Medicaid limit, and if you give those assets away to try to qualify for that Medicaid limit, there's a 5-year look back. They look back over the last 5 years of your life to see, did you give away any assets over the past 5 years to re-qualify for Medicaid? For SSI here in Pennsylvania, it's a 3-year look back. In Pennsylvania, I will say ABLE accounts are okay. There is no look back in Pennsylvania for transfers for Medicaid to an ABLE account or for SSI to an ABLE account. That's something that is going to be very, very state specific though, and very program specific too. So different programs under Medicaid, for example, could have different qualifications on that. I know HUD Housing just implemented a new asset limit, and they have a different look back. So it's very program specific, very state specific. Great question though. This could be, ABLE accounts could be a good resource for asset preservation that might get you around those look back periods. Good job. Yeah, good question.
Yeah, hi. For an individual who is affected by RYR1 conditions, yeah, but let's say is working, is going to collect Social Security, has retirement accounts, how do these different elements, especially the ABLE accounts, interact with those issues?
Yeah, fantastic question again. So this is where, I'm going to try to go back here to my ABLE slides. Wow, we covered a lot, guys. It's taking me a while to get back here. So one of the reasons why someone with RYR1 who is working, who does have their own resources built up, might still be looking at an ABLE account is because of that tax-free growth that they get. They might look at an ABLE account as another resource, not looking at this as an option for continued qualification for any types of government-funded services and supports, but maybe looking at this as another type of resource that kind of operates similar to a Roth, that can get that tax-free growth for federal and possibly state services. And looking at the qualification, again, it's possible that someone with RYR1 who is working, they're not receiving SSI, they're not receiving Medicaid, If they can prove, and if the caseworker reviewing their application determines that they have a physical impairment that has extreme limitation in moving about and manipulating objects, I think they could qualify. Again, that's going to be a gray area, but I think someone with RYR1 who is working, who is building and saving their own assets for retirement, might be still looking at an ABLE account as another tax-free growth financial planning option for them.
This is like the perfect slide to have on here. That was kind of my question for the trusts, is in terms of what is considered disability, is that also this more expansive list than not just being on like SSI or Medicaid?
Great. Yes, that's correct. You don't need to just have, there is no definition of a disability to have a trust. Again, this is something that might differ between states. Estate planning and trust planning is very state specific. I will say here in Pennsylvania, whenever I'm drafting the trust, the restriction that I build into the trust is whatever services and support someone might qualify for in the future or now, the trustee should not be spending the money in any way that could impact the eligibility for those services. If that person is not receiving any services and supports, everything's wide open then to spend the money on. So oftentimes I'm thinking about a third-party trust, and I might be using a third-party trust, even if the beneficiary is not currently receiving any services and supports, but we have concerns that maybe after a loved one passes away, they might be looking at new services and supports, especially if a parent, the grandparent, the person I'm meeting with is the primary caregiver for their loved one. And we're thinking after that person passes away, are we going to be looking at any other types of home-based or community-based services being brought in that we're going to be looking at some other options for? So we could be doing some kind of future planning like that too with those types of trusts. Yes.
Just prior to your presentation, one of the attendees was talking to our group regarding congressional action, reaching out to our congresspeople. Yeah. And I'm wondering if the compassionate allowances list is a place to start in terms of having that list include RYR1 individuals. Does that make sense to you?
I think it does. I think it is certainly worth reaching out to your representatives to see, can we expand this list to have RYR1 on this compassionate allowance list? Mm-hmm. I think something that they might be looking at when they're determining whether a medical condition should be added to the compassionate allowance list is how often does an individual with this medical condition qualify under their definition of having a disability? If it is an area where, as we mentioned, someone with this medical condition is working, not receiving services and supports, it's possible that someone reviewing an application for an ABLE account for someone with RYR1 might determine that this definition is not met. A lot of the conditions on the compassionate allowance list, in my experience and in my opinion, are conditions that almost every time someone with that condition is probably going to meet this definition, and so we're not going to go through the rest of the determination. Mm-hmm. So I think it's certainly worth talking with your representatives to see, is this something that we can be added? I think it would be very helpful for individuals in the RYR1 community to get to bypass this type of determination and give access to this ABLE accounts. I'm all for ABLE accounts, and I'm so glad that they are, for example, raising the age on January 1st to give this access to give more individuals access to this account. Okay. I think that kind of advocacy could be something that could be very helpful.
Great. I have two other quick questions, if I can. You said the ABLE account is going to be owned by the individual. Yes. If the individual is a minor and it's an online account, then who's recognized online as who's the signatory, so to speak?
Yes. So it's either going to be their parent or their guardian.
Okay. And then if there's money in the ABLE account and we want to use it for education needs, how is it withdrawn? Is there a checking account, capability adjacent to the account, that kind of thing?
There could be.
ATM card?
Some types of ABLE accounts are set up as a savings or checking account. This could be something that differs among states too, how different states design their ABLE accounts and how those transactions are going to look. My understanding under Pennsylvania is someone would withdraw the money, get onto the PA ABLE website, and do the electronic transfer of funds out of the ABLE account into the individual's other account, their other savings account or checking account, and then use the money. But that is something that could be different depending on the type of ABLE account and the state's program and the own state's rules.
And then somehow we have to verify that so there's no tax consequence?
Correct. Keep records of how that money was spent.
Thank you.
We have, yes, last minute. Great.
On the qualifications for an ABLE account, if an account is set up for a qualified minor who, through years of treatment and physical therapy, somehow would no longer meet those qualifications, what happens then?
That's a great question. I have not run into that before. I am not sure, again, that's something that each state might have different procedures. My understanding, I have not heard of any of my clients who qualify for the ABLE account. I have not heard that ABLE continues to monitor eligibility. Like someone who's receiving SSI or Medicaid, every year you got to go, they check in to see, do you still qualify? I'm not seeing that continued monitoring for ABLE. That could be something that could change though and might be different. But yeah, great question. Okay, thank you so much, everyone, for your time, for your questions. I'm going to be around the rest of the afternoon, so if anyone, feel free to come up and talk and ask any other questions you have as you see me. Thank you, everyone. Enjoy your day.